I'm Diane Buckner. Carol is off this evening. A court case in Ontario is raising a lot of questions about family obligations. A mother is suing her daughter's grandparents for monthly child support and wants back payments as well. The grandparents say while they love their granddaughter, they shouldn't be forced to pay. The case could set a precedent and has garnered a lot of interest. Sarah Galashan joins us now to talk about what's at stake. Sarah.
Well, Diane, at stake is the access that Diane DeForge and Conrad Hunter have to their 10-year-old granddaughter, who, as you point out, they say they love dearly. Their son, the child's father, passed away a few years ago. They say they would be devastated if they couldn't have regular access to their granddaughter, which they currently do have. They see her regularly every other weekend. But for that to continue to happen, the child's mother says that she requires support. She wants financial support, and she has filed a suit to try and make that happen. If you want, we can put the numbers up for you. What she's asking for is $760 a month in child support, but not just that. She wants back payments, as you say, so retroactive payments to the time of the father's death in 2013, and that would total $47,000. So not an insignificant amount of money. The lawyer for the mother not saying much about this case other than it is his feeling that these grandparents have played more of a role in the child's life than your average grandparents would. About 7 years ago, they did have emergency custody of their granddaughter for a period of time that was about 8 months. As well, they were made legal parties in the custody dispute between their son and the child's mother. So, Diane, all of that's going to play a part in this.
Right. I mean, there's a lot of different details in this case that are quite specific to this family, but could potentially have a wider impact?
Well, this part of the law is a little bit of a gray area in Ontario. As of last year, the law in that province gives grandparents certain court-ordered rights if they want them, i.e. visitation and access to their grandchildren. Of course, they have to go to the courts to make that happen. But as for child support, that's in a different section of law. This case, though, could tie those two together depending on what the judge decides. So these grandparents say that they're fighting this not just for themselves. Take a listen.
We love her to pieces and would do anything for her, but she's not our child.
If we turn around and end up having to pay child support, I mean, that's just going to open up a floodgate.
DeForge and Hunter did have a court date set today. No word yet right now, Diane, as to what their next steps might be.
All right. Thank you very much. That's the CBC's Sarah Galashan in Vancouver. So what could the ruling mean for future cases? Joining us now for more on this is Maniza Sheikh. She is an employment lawyer and partner at Levitt LLP. John Schuman is a certified specialist of family law and a partner at Devery Smith Frank LLP. And Sean Spear is a senior fellow at the Macdonald Laurier Institute. So John, Maniza, and Sean, interesting case here involving grandparents wanting child support. John, you work in family law. Is this ever been heard of before, this sort of case?
Well, it's not. This is the first time I've heard of it actually going to trial, I think is what's going to happen next. But when you have, especially when you have a death of a parent and you have in-laws who want access, you often have parents fighting back by asking for child support. Don't see a whole lot of seeking child support from extended family. It's more common for step-parents or other people who have really stepped in and are more closely related to the child and stepping in as a place of a parent in that role.
Mm-hmm. And now let's get into the big topic here, which is it fair to ask grandparents to help support their grandchildren? Maniza, what do you say to that?
I can see from both perspectives, and at the end of the day, it starts to look a little bit like a custodial relationship. It starts to look a little bit like, mom and dad who are divorced, and mom's got, I should say, access every other weekend. But at the end of the day, my understanding, at least of the cases, these are not custodial. They don't have a custodial relationship. They have access. And what I worry about is, if the judge does end up making this sort of unprecedented decision, the policy impacts. Like, are we now now going to have a situation where people are viewing this as paying for access? And more importantly, are we going to have a situation where grandparents, to the detriment of these children, are not going to seek regular access of their children, whether, if they're dealing with a husband and wife who are estranged, or like in this case, one of the children have died. So I think it could have far-reaching policy implications. And I think ultimately it's the children who are going to have to bear the brunt of it. And that concerns me as a parent, and it concerns me as a lawyer.
Mm-hmm. Now, Sean, you're the policy guy. You hear Maniza talking about policy implications, but before we get to that sort of official level of things, what's your reaction just when you hear that this is happening?
Well, I do think it is important to step back from this particular case and think more broadly about the legal regime that we want in place for instances of where the state may need to intervene because of circumstances in the home, or in the event of the passing of parents. I think we want to ensure that we have a policy and legal regime that, all things being equal, creates the conditions for children to live with other family members before having to pursue other options, including the foster care system. And the reason that's the case is because there's a wide body of social science evidence that in those circumstances, remaining together when there happens to be more than one child, and living with the extended family as opposed to moving through the foster system, produces better outcomes. And it's not just the abstract data. I mean, we know this from personal stories. Think, for instance, of the best-selling book by J.D. Vance, Hillbilly Elegy, in which he makes a pretty powerful case that it was the intervention of his grandparents that really created the conditions for a better life. And I think people, even in my own lived experience, one of my best friends in Thunder Bay, his parents stepped in and when his cousin's parents, or his aunt and uncle, were tragically killed in a car accident, and really changed the lives of those cousins, of what are now his brothers. So I think the important thing here is that any judgment doesn't erode, I think, what has become a fairly solid policy and legal regime in these circumstances.
But I mean, one of the interesting things about all of this is that a lot of grandparents have been fighting for their rights, right? I mean, we live in this era now of so many broken families, so many husband and wives separated, custody battles, all the rest of it, and very often the grandparents get lost in that. So this is sort of the opposite of, okay, well, grandparents, you're going to have an even bigger obligation if you want to be in the children's life. But in fact, grandparents have been wanting to be recognized as perhaps having more rights, have they not, John?
Definitely. We've seen a lot of legislative changes across the country giving grandparents the right to seek custody, or where they even had it, that there's more emphasis in the legislation that judges have to consider them as having access, because there's a recognition that grandparents can play a very special role in children's lives. And it is true that when you have parents who can't parent, you absolutely want to have children's aid societies turn first to grandparents or other extended families to look after them. That's one of the most chilling aspects of this case, and what I think children's aid societies can worry about is that grandparents will say, no, I can't risk having to pay child support for the rest of my life. But even outside of that, we also live in a changing society. The child support guidelines were drafted in 1997. It's been 20 years. And now we have a lot of families where, because of daycare obligations, because work days are longer, or there's more shift work, or income or is more precarious, or because of cultural norms, that families, extended families, are more involved in children, and that's needed to be more involved. And of course, it's much better to have extended family involved with the children, and even in some cases where you have them very involved children, and you don't really want to split up, especially in situations where the norm for the family is to have grandparents, aunts, uncles, cousins all involved. You don't want to divide them up all out of fear of having to pay child support one day if the child's parents break up. And there's, I think that could be a chilling influence if this case is decided that these grandparents have to pay child support.
And may I just add to that? Sarah described the particular case in the setup. And in this instance, the grandparents intervened for a brief period of time. I'm afraid I don't know the circumstances. But what happened in the intervening time was the mother was able to address whatever underlying concerns there were, and ultimately the child was able to return to the home. That's an example of the system succeeding, particularly in an era where we're seeing serious issues of substance abuse. The opioid crisis is crossing the border into Canada. And so family members, grandparents may step in for short periods of time as family members, as parents, go through treatment or other steps to get them back into a position where they can properly care for the child. And the risk of this case is it really puts a chill, as my colleague says, on that type of short-term respite. And I think only to the detriment of, ultimately, these children.
Well, but this was the point, just as you're saying, when this little girl is now 10, when she was 3, apparently the grandparents had to step in an emergency custody situation, which we have very few details about. But in any case, the fact that they did that they stood in as parents, this is what has now opened the door to this case that the mother can bring to say, well, you need to pay child support. But Maniza, I'll direct this question to you. I mean, you know, the grandparents have already raised a family. They've already paid child support for their own children. How could you legally obligate them now to pay for their children's children?
Well, I'd be interested to hear from my colleagues on this as well. But my view, of course, is I think the position that the mother is taking, you know, on the one hand, you know, you could say, well, you know, in order to be liable for child support, a grandparent has to take an active role in the parenting. And it sounds to me, again, without knowing the details, that they have taken that active role. But on the flip side, I mean, I don't necessarily think it sounds like mom has the best interest of the child at play. And I'll tell you why I think that. Essentially, you know, she's also said that in the event that the court, you know, in the event that they're not ordered to pay the support right away, what she'd actually like to do is block access. And in my view, that's an extremely punitive ask for her to be making, because ultimately the courts would be really hard pressed when it is their job to ensure that they're looking out for the best interest of the child. They'd be really hard pressed to create a scenario where access is blocked off. So I don't think it's just about her asking for support. I think we should also be extremely concerned about the fact that she hasn't listed that there's been any problems with the grandparents looking after these children, but the fact that she's saying, look, if they don't pay up the big bucks, then I don't want the kids to see them anymore. And I think that's something that the court should be concerned about, because there's a Court of Appeal decision from 2001 that speaks to, you know, allowing the parents' best interest to outline access. I mean, here there's obviously an access order, as I understand it, but, you know, where there would be detriment to the child's interest, the court should intervene. So I am really concerned about that aspect of this case as well, and I feel that there hasn't been enough discussion about that.
Well, it's an unfortunate story because, of course, first of all, the parents were separated. There was a custody battle. Then the son was killed in an accident in 2013. So now this woman is alone raising the child. So obviously she has an incentive to look for support there. But another issue that affects this case, and I wonder if this would also have spillover to other cases across the country, is that the grandparents somehow also got drawn into the custody battle. They had some sort of official status as being party to that custody hearing, and that they didn't mind that at the time. Like, again, this goes back to grandparents wanting to have more rights and having a role. They thought that was a good thing. Now it's coming back to bite them, John. Is that the sort of thing that you could see coming to other provinces as well?
Well, I mean, that's an interesting and unique aspect of this case. We have the grandparents involved in like the actual divorce, the initial separation. That doesn't happen that often. Usually what happens is the divorce happens, whoever the one parent doesn't see the child much, and then the grandparents don't see the child much, and then those grandparents want to see more, so they come back and ask for more access. It sounds like in this case there was some concerns about parenting that, you know, originated from when the Children's Aid Society was involved, and so the grandparents stayed involved with the family, and they had probably, as a result of that initial involvement, become very close to the child. And it made sense that at the time when the parents were separating up, to make sure that these grandparents who had been very close to the child and probably were continuing to be some sort of psychological parent for the child, because obviously they were the parents of this child at a very important time in that child's life, when the child was between 3 and 4. So the child probably sees them as parents, so you don't want to let them get cut out. And so that's probably how they were involved, because that happened before even the changes in legislation, which put more emphasis on grandmothers. So I think originally the judge recognized the importance of their of the access between the child and the grandparents at that time. And that being the case, there being recognition of that, I think that a family court judge in Ontario, and probably just about any jurisdiction, is going to be very hard pressed to stop that access, because that's not in the best interest of the child. When just because mother wants child support or they're not paying child support, I think a judge would rather take away their driver's license and have the punishment fall on the parents than to have stopping access between these grandparents and a child who clearly must have a great relationship with them in order to have that sort of access order in place.
I just wonder whether grandparents all across the country are going to be watching this case, particularly ones in situations where there has been a marriage breakdown, and wondering, are they going to have some kind of a suit coming towards them? What do you think, Sean?
Well, exactly right. That's why I think it's terribly important that we step back and think about this from first principles. What are the objectives we want our legal and policy framework to support? And I think what the Ontario legislature passed last year was an affirmation of the importance that the extended family, including grandparents, can play in the raising of children, particularly in instances where the state needs to intervene because of circumstances at home or because of the tragic passing of a parent. And I think it'll be incumbent on the judge, I think, to keep in mind that policy objective as he or she deals with this case. And ultimately, depending on that judgment, this may fall back to legislators, to the Ontario legislature and to provincial legislators across the country, to ensure that we have a regime in place that places an emphasis on the role of the extended family, particularly grandparents, in these instances of family breakdown or other issues in the home, because, as I say, we know from both qualitative and quantitative evidence that that's ultimately in the best interest of children. And I think hopefully in this case, cooler heads prevail and the interests of children are upheld.
All right, John Schuman, Maniza Sheikh, and Sean Speer, thank you so much for being with us tonight.
Thank you.
Thank you.